Good afternoon, ladies and gentlemen. When I normally get to this stage of a trial, I'm pretty much a creature of habit. I like to just kind of cover just a few principles, things that we've talked about already, but I just kind of want to remind you of those. First thing I like to say is what the lawyers say, not myself, not Ms. Palmer, not Mr. Hale, not Mr. Champion. There's evidence. At this stage, you have heard all of the evidence, and it's all sitting over there in that corner, and you'll be able to take it back there in the jury room with you, and you'll be able to refer to it during your deliberations. So, one of the statements, or one of the jury instructions that the judge read to you was that, and it's in one of the jury instructions, he said, any argument, statement, or remark having no basis in the evidence should be disregarded. If I make a remark to you, please don't think that I'm trying to mislead you. Disregard what I'm saying. I am making comments on what I believe the evidence has shown this week. Okay? You are the sole determiners of the facts in this case. There's been testimony from that witness stand. There have been exhibits offered and accepted into evidence from that witness stand. You determine what the facts in this case are. The court will tell you what law to apply to those facts. But you determine what those facts were. You determine what testimony you want to accept from that witness stand. I mean, not any of the other lawyers. You. That is your sole province as jurors. And you're going to do that by reviewing the evidence, the photos, testimony, the pictures, exhibits, all of which, as I said, you'll have the benefit of when you go back to that jury room. And then finally, there's been a lot of talk, and I use this term, but sometimes I wonder if there's any basis to it. People always talk about use your good common sense. I'll let you define that one on your own. One of the things that was said early on in this trial, I think about, well, this was actually said during jury selection when we were back there in Starkville. I think Mr. Hale may have said, I made a quote. It says, knowns are facts that won't change. And I agree with that assessment totally. But I want you to realize is that the state of Mississippi has a burden of proof. All I want you to do is to hold them to that burden. They have the burden of proving to each of you that Mr. Tellers committed this crime. And in doing so, they have to satisfy every element of the crime as set out in those jury instructions. Now, the court has also already told you, all of these jury instructions have been read. It said don't give any particular jury instruction any more weight than the other, but consider each and consider the packet as a whole. But now, I like to emphasize the jury instruction that I believe that you should pay attention to. You make that decision. As I said, this is just a comment on what I think you should consider during your deliberations. Now this jury instruction, it says, if there's a fact or circumstance in this case that's acceptable to two interpretations, one favorable, one unfavorable to the defendant, Quentin Tellers. And when the jury, you, has considered said facts or circumstances with all of the other evidence, and there is reasonable doubt as to the correct interpretation, then you, the jury, must resolve such doubt in favor of the defendant, Quentin Tellers, and place upon such facts or circumstances the interpretation most favorable to the defendant, Quentin Tellers. The court instructs you, and I'm reading now, the court instructs the jury that if you can reconcile the evidence upon any reasonable hypothesis consistent with defendant Quentin Tellers' innocence, you should do so and find him not guilty. That's what we're asking you to do in this case, ladies and gentlemen. Now, you have heard all the evidence, and while sitting here preparing for this trial, while questioning witnesses, while listening to testimony from that trial, while looking at videos, I find myself asking this question all week. Why does there appear to be a concerted effort during the course of this trial to totally discount the statements and the information that was gathered by the first responders who initially responded to Ms. Chambers on this evening? Firemen, EMTs, law enforcement, all responded initially to this call, which was originally called out as a car fire. Out on Heron Road, we went there. And without belaboring this point, 8 of those individuals, and don't take my word for it, ladies and gentlemen, you actually have the statements of the first responders who were there on December 6, 2014. They're written statements. And when you review those, this is what you're going to find. Who did this to you? Eric set me on fire, in quotes. But now there seems to be such a concerted effort to discount all of that information, and by virtue of calling witnesses to discredit, for lack of a better word, to basically say that these people didn't hear what they said they heard or what they thought they heard. One thing that sticks out in my mind is Mr. Haley's. Mr. Haley was asked to imitate the sound, and I believe he said, Eric. But in his statement, he said, Eric set me on fire, in quotes. And he wrote that statement shortly after this happened. So without belaboring that point, you have those statements there in evidence, ladies and gentlemen. I'd ask you to review those. I'd ask you to consider those during the course of your deliberations. There's been a lot of evidence and testimony here. Watched a lot of videos. There was some struggles at least by me to keep my eyes open during that time. I don't know if you had a similar experience. But now, I'll tell you what I did find very interesting. There was testimony by Mr. Rowlett. Mr. Rowlett put together a very nice little PowerPoint presentation. I'm sure you're aware of that. I believe that testimony was entered on yesterday. It was 102 pages, thumb drive, color, copies. You'll have the benefit of that. But now, what the state, through that presentation offered to you by Mr. Rowlett, they would like to paint Mr. Tellis as basically a super criminal. And I'm going to kind of go through a portion of that. And you can refer to it. Just take a look at it when you get back to it, if it's of any interest to you during the course of your deliberations. I'll give you a reference point. You saw these in color on this big screen yesterday, but this is 65. And if you recall, at 7:26, there was lights on the CCTV, which was a closed circuit TV camera. And according to the state, that is when Mr. Tellis left the second driveway that they're talking about. If you recall, you know, it was circled with a little red pen. You looked at it, he faded to black and he lightened it up so that you could see where it fell on the video screen. But at that point, you saw headlights, and they turned and they went down 51 away from the store, you remember Gurley's, and out to the crime scene, according to them. But all you saw was some headlights come out of a driveway, and they allege that they went out to the crime scene. Now at this point, based upon what they're saying, Ms. Chambers was already incapacitated in some way. And Mr. Tellis was taking her out to the crime scene to do whatever he was going to do. And by the way, as he was leaving, he passed a fire, which really wasn't a fire, at the entrance there to Old 51 in the trailers, okay? And while he didn't think about it then, maybe, in the back of his head, after incapacitating Ms. Chambers, he was thinking alibi. That's going to be a benefit to me at some point, okay? Now, Mr. Rowlett talks about putting this puzzle together, and I think he used a reference, a 1,000-piece puzzle, and he says maybe about 100 of those 1,000-piece puzzles thrown on the floor. And at the end of that day, he put together this picture of Quentin Tellis after 4 years. I submit to you, ladies and gentlemen, this is what happened. They initially considered Mr. Tellis. They pursued a bunch of leads. They couldn't find the person who did this atrocious crime. They came back to Quentin Tellis and they started working backwards. And they started putting together evidence. They came up with a picture, and then the job was to make it fit into their theories. Let's talk about these theories. I told you about 726. Mr. Tellis is going out. Ms. Chambers apparently, and this is their theory, and this is from their PowerPoint presentation. He's headed out to Heron Road. And out the corner of his eyes, he sees these fire trucks over there at Miss Julia's house. I think, according to Miss Flowers, his Aunt Julia. So he's going to use that information. So he goes on out to Heron Road. If you recall, this is what you saw. You saw the headlight. But did you see Quentin Tellis? No. You saw headlights, and the state wants you to make that jump to say Quentin Tellis was in the car with Jessica Chambers and he was taking her out to Heron Road to set her on fire. But you don't see anything but headlights. They want you to jump. They want you to speculate. I want you to hold them to their burden of proof and make them prove this to you. At 726, Ms. Chambers' phone was dead. Again, you can see this. This is slide 70. But now, if you recall, the fire truck, it was towed out at 7:02. It would have left there at 7:30. So he left, so he had 4 minutes to actually observe this fire truck and put it in his mind as an alibi. Okay? He goes out to Heron Road. Apparently, with Ms. Chambers in this vehicle, incapacitated, pulls up on the hill, and then what does he do? He walks back. According to the state, he's walking back. And along the way, the state wants you to believe that he dropped these keys. Now, we went to that site. These keys were right across from Ms. Flowers. I'm going to talk to you a little bit about her more in a minute, but these keys were actually, this is slide 74. These keys were actually dropped in the driveway or in the yard right across the street from where Ms. Flowers lives. The state wants you to believe that Quentin Tellis put them there. The state wants you to believe that Mr. Tellis's DNA is on those keys. You heard the testimony. Do you recall? She did 2 tests on these keys. The first one, the more specific test, says Quentin Tellis is excluded. She left his name off, but he was excluded. She admitted that from the stand. On the second test, she said he could not be excluded. And the question was asked by the state, is the question was asked by Ms. Palmer. Can you say that his DNA is on those keys? No. What I can say is that he cannot be excluded. So these keys were dropped. Miss Flowers, she comes home with her grandchildren. It's dark. And she gets her grandchildren coats. And she backs out. And she leaves. And she heads back up to 51. Now, she didn't pick Mr. Tellis up there. If you recall, we were out at the site visits. We went to the place where the fire was. We came down to where the keys were, and we jumped back in the vans. We went up the hill, around the curve, down the hill, and stopped, and there was an orange dot in the road around the corner from Miss Flowers' house. That's where they alleged that she picked up Mr. Tellis and gave him a ride, who, by the way, asked which direction you were going. Well, it was only one direction she could, because she was headed up to 51. And the reason I want you to remember this, and what will help you remember this, is because during this time, Mr. Hale referred to the landing zone. I think he asked the court to ask you to look to the left as you crossed over the railroad track so that you can see where the helicopter landed. Okay? So, 7:26, Mr. Tellis has taken her out to Herring Road, according to the state, dropped her off, and he is walking back now, and Ms. Flowers picks up this mail. But now, during the course of this trial, several individuals identified Mr. Tellis because they knew him. But did you see Ms. Flowers identify him? She never identified Mr. Tellis as the individual she picked up that night. Never. And ladies and gentlemen, if Ms. Flowers could have testified that Quentin Tellis was the man she picked up that night when she was sitting on the witness stand, don't you know what she would have? You make that decision. What I say is not evidence. But use your good common sense. So she picks up a mail, no idea of who this is, an individual that she picks up at night with her 1-year-old grandchild in the car and her 5-year-old grandchild in the dark, and she comes forward with this information roughly 4 years later. I don't know what motivated Ms. Flowers to testify to that. But assuming that she picked up someone that night, she doesn't know who it was. She didn't pick up Quentin Tellis, and she didn't tell us that she picked up Quentin Tellis that night. So, 7:26, Mr. Tellis has left, went out on Herring Road, walked all the way back around to where this green dot is, according to the state. Now he's picked up by Ms. Flowers and taken to the top of this hill. The state wants you to make that jump, ladies and gentlemen. There's been no evidence of that. There's been no evidence that Mr. Tellis was picked up. There's been no evidence that Mr. Tellis dropped those keys in the yard. But the state wants you to make that assumption based upon the evidence. Based upon what evidence? Based upon no evidence. Now, while Mr. Tellis is doing all of this, from 7:26 to 7:46, 20 minutes later, according to Mr. Rowlett, he has incapacitated Ms. Chambers, driven her out to the space on Herring Road, has walked back around to where you all saw the orange dot at, and at some point he is thinking, I need to send Jessica some alibi texts. So he's thinking alibi, according to the state would have you believe that he passed the fire 10 minutes later and immediately categorize that as an alibi so that he can tell Miss Flowers that, yeah, I need to go up here and check on my auntie whose house caught on fire. And at the same time, he is thinking, let me do some alibi texts. So at 7:42, there's a call from Mr. Tellis' phone to Jessica Chambers. It was not answered. And then he sent Bay, my friend coming over tonight. Call you tomorrow, good night, sweet dreams. Now, State would have you say that that's a text unlike you've seen before. But what did he say when they were talking about money? How much you need, Bay? He used very similar language then. He didn't create any additional language. 7:46. She drops him off, according to the State, and he's heading over to Ray Gann's house to get her vehicle. Okay? And you'll remember this because it's now 7:50. It is actually 22 minutes later, 24 minutes later. You do the math. You're going to have it with you, ladies and gentlemen. But according to Mr. Rowlett, what do they see at this point? At 7:50, they see slow-moving lights on 51, and they turn into this driveway of Quentin Tellis. This was another one of the pictures that you all looked at from day to night, just to show you where it was. So he turns in there, and it stops. What did you see? You saw headlights. I don't think we could even see what kind of vehicle it was, but you have the benefit of reviewing that video footage when you go back for your deliberations. At 7:52, this vehicle leaves, and it goes back out to what they say is a crime scene. Now, it heads in that direction. They want you to make the jump that, again, that was Quentin Tellis at 7:52, who had left, taken her out to Herring Road, walked back to the point of the orange dot, got in the vehicle with Miss Flowers, came and got his sister's truck. And what they want you to assume at that point is that when this slow-moving vehicle went into that driveway and stopped, what was happening is that Mr. Tellis was getting a gas can so that he could go back out and set Miss Chambers on fire. They want you to make that jump, ladies and gentlemen. But have you seen any evidence of that? You have not. You have seen headlights. You've seen no evidence that would indicate that he was even in one of these vehicles. But the same vehicle pulls out and goes back in the direction of the crime scene. The State again wants you to make that leap, ladies and gentlemen. Hold them to their burden. That's all we ask. (8:04), the State shows you a picture. This is around slide 88. And that picture is a vehicle, this time moving at a high rate of speed, up 51, towards Batesville. There's been no identification of who was in that vehicle, ladies and gentlemen. There's been no identification that Quentin Tellis was driving that vehicle. Mr. Tellis, in the course of one of his many interviews, said, yeah, that could have been me. Mr. Tellis never denied going to Batesville to get this green dot. But they're wanting you to make the assumption that Mr. Tellis was leaving the crime scene and he had just set Miss Chambers on fire, and he was leaving to go and create the third alibi. The first alibi would have been the fire at his Aunt Julia's house. Now, we heard testimony that she's not his aunt, and Miss Flowers recalls, or her reasoning for allowing this individual to get in the vehicle with her on this particular evening was because she knew this lady who fixed her hair 20 years ago. At 8:04, according to the state, Mr. Tellis was headed up to Batesville. So from 7:26, Mr. Tellis backed out of his driveway with Miss Chambers, incapacitated, took her out on Heron Road, pulled up on this hill in this vehicle, left her, walked back around to where this orange dot was in the road, caught a ride with Miss Flowers, went up to his sister's house, got the truck, went to his house, got the gas can, came back, set her on fire, went back up to Batesville in the course of that time, 7:26 to 8:04. That's what the state is alleging, ladies and gentlemen. In my opinion, that is utterly ridiculous. But that's not my decision to make. You look at the evidence, you look at their timelines, you look at this intelligence report that was put together by Mr. Rowlett, and you make your own determinations. The state wants you to make jumps. I want you to hold the state to their burden. I want you to make the state prove every element of this crime. And I want you to make the state prove that Quentin Tellis actually committed that crime. I think if you take a serious look at that evidence, at everything that was presented by the state, if you disregard everything that the lawyers said and look at the evidence itself, I think the conclusion that you will come to is that Mr. Tellis is not guilty of the commission of this crime. And when you make that conclusion, you'll find him not guilty. Thank you.